Disqualifications render any person incapable of being chosen or of sitting as a senator or a member of the House of Representatives. The disqualified candidate is not and cannot be a parliamentarian. In fact, if a person is disqualified and still sits as a parliamentarian, according to section 46 of the Constitution, that person will pay a fine. And in section 44 we can identify 5 categories of disqualifications. They are allegiance to a foreign power, criminality or treason, bankruptcy, profits under the crown, and pecuniary interests. This is not an exhaustive list, however, because states can also impose further disqualifications on their candidates. So in this video we're focusing on the disqualifications of section 44 of the Commonwealth Constitution only. But it is important for you to be advised that maybe there are some other disqualifications as well happening at different levels of the Federation. The thing is that many individuals have fallen prey of this section in the Constitution, so it is important for you to know the qualifications according to section 34 and the Commonwealth Electoral Act, and also the disqualifications of section 44. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll look at the disqualifications of section 44 of the Commonwealth Constitution. The first thing that you should know is that disqualifications may arise during nomination, that is, before elections, but it's also possible for them to appear afterwards. In a case called Sykes and Cleary, the High Court of Australia has said that disqualifications that we will be soon looking at, they apply from the moment of nomination. So if you want to stand for elections as a candidate, you cannot fall within any of the 5 categories of section 44. But remember that section 45 of the Constitution refers to the supervening disqualifications. That is, even after being elected, you cannot do the things that section 44 of the Constitution refers to. If you do, your seat will become vacant. Now, in this video, we're focusing on explaining the content and the idea behind each one of these subsections. In my next video, we'll look at the cases decided by the High Court of Australia that refer to each one of these subsections as well. Make sure you have subscribed to our channel and that you've clicked the bell icon so you don't miss it. So let's start with the first disqualification. Section 44(1) of the Constitution says that any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is subject or citizen of a foreign power, shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. Foreign allegiance means a bond which attaches a subject to his sovereign. So allegiance to a foreign power happens when a person is born overseas or acquires a new nationality through naturalization. The term that is used in the Constitution is subject, as in subject of the Queen, because that's usually the term that exists in monarchies. But the idea here is the same as in a citizenship. So just replace the idea of a subject to the idea of a citizen. And that's why this disqualification is also known as a dual citizenship. If someone is a dual citizenship, that is, he or she is a citizen of Australia, but also a citizen of another country, they owe allegiance to this foreign nation. And therefore, they can be disqualified under section 44(1) of the Constitution. A dual citizen is disqualified from holding a seat at the federal parliament. But this allegiance can happen not only by having dual citizenship. One can also have a de facto allegiance without necessarily having the citizenship of another country. For example, one can accept a foreign passport or even serve in the military of another country. That will all constitute an allegiance. But the words of the Constitution say allegiance, adherence, or obedience to a foreign country. So it's not all acts that could amount to an actual allegiance. There must be some substantial commitment to the foreign country for this disqualification to apply. Further, section 44.2 of the Constitution says that a person will be disqualified if the person is attainted of treason or has been convicted and is under sentence or subject to be sentenced for any offence punishable under the law of the Commonwealth or of a state by imprisonment for 1 year or longer. There are two restrictions here. You cannot have been attainted of treason, and you cannot be serving or be subject to serve a sentence of imprisonment of 1 year or longer. So first of all, what's treason? According to section 81 of the Commonwealth Criminal Code Act, treason occurs when someone causes the death or harm to the sovereign, the Governor General or the Prime Minister, levies war against the Commonwealth, or instigates non-Australians to make war to invade the territory of the Commonwealth. A person being convicted of treason and never pardoned is forever prevented from sitting as a parliamentarian in the federal parliament. Thank God. So the second part of the provision is, I guess, closer to our reality, because the second part refers to any offence that will make you liable to being in prison for at least 1 year or more. An offence is some act or omission which is triable and punishable, either on indictment or information, in a superior court before a jury, such as a felony or misdemeanor, or summarily before justices, according to the direction of the law creating the offence. So if you committed treason, or if you are in prison, or is subjected to be in prison for 1 year or more, you would be disqualified. But hey, this does not mean that everyone who has ever committed any of these offences will be disqualified. The High Court has said in Niall and Wood that if a person has served their sentence, then that disqualification is at end. The disqualification only applies to those who are under sentence or are subjected to be under sentence of 1 year of imprisonment or more. Section 44.3 says that a person will be disqualified from sitting as a member of the House of Representatives or as a senator if the person is an undischarged bankrupt or insolvent. The interpretation of this section, to be honest, is pretty straightforward, and its application is almost non-existent. As Lumb and Moens say, the test is whether a court has declared a person insolvent and that a person has not been discharged from their insolvency. Ultimately, the reason behind this provision was the stigma that came with someone who was an insolvent or a bankrupt, that is, someone who couldn't administer their own finances, to administer the public purse. How could they do that? But the problem is that with our new economy, free market, startups, etc., this sort of provision kind of evaporated. Everyone is attempting to do something and create something new, and they are therefore liable to being insolvent and even bankrupt. So it's because of these new conditions in our society that some have suggested this disqualification to be abandoned and excluded from the Constitution. Nonetheless, this provision still has some reasoning behind it to prevent people who are careless with finances from directing and conducting public policy in Australia. Section 44.4 refers to a person who holds any office of profit under the Crown or any pension payable during the pleasure of the Crown out of any of the revenues of the Commonwealth. This section means that if you are a public servant that is employed by the Crown in right of the States or the Crown in right of the Commonwealth, you will be disqualified from serving as an MP or senator. An individual cannot be employed and receive pay or pensions from the Crown and still sit as a parliamentarian. There are some exceptions though. Section 64 of the Constitution says that the ministers of the Crown must sit in Parliament. So these people are actually holding offices of profit under the Crown, but they are not under this specific subsection of Section 44. Also, the disqualifications does not reach the members of the Queen's Army and Navy. They are also outside the scope of the Section 44.4. Graham Moore reminds us that in many states and in New Zealand, the disqualification has been streamlined so that public servants who stand as candidates are immediately placed on leave without pay. If elected, their employment is automatically terminated. However, the rule for federal elections is that the disqualifications apply at the moment of nomination. That is, you must resign before nominating yourself as a candidate. If you want to stand for elections as a candidate, you must not hold an office of profit under the Crown. This is a consequence of a case that I mentioned before called Sykes and Cleary. We will talk about this case in my next video. Again, make sure you are subscribed to our channel so you don't miss it. The idea of section 44.4 is to prevent the Crown from influencing Parliament. Remember, there was a long history of establishing representative and responsible government in Australia and separating an absolute monarchy from a constitutional monarchy. Allowing parliamentarians to sit as employees of the Crown could potentially lead to some dangerous situations where the Crown could use its resources and finances to influence the decisions of Parliament. So the provision aims to avoid corruption, to avoid one branch of power influencing the other. This exists to guarantee the independence of Parliament. And the same happens with section 44.5, where it refers to those who have any direct or indirect pecuniary interest in any agreement with the public service of the Commonwealth, otherwise than as a member and in common with the other members of an incorporated company consisting of more than 25 persons. A person with pecuniary interest, that is financial interest, in any agreement with the Commonwealth is also liable to corruption. They can be influenced by their contractual partner. If there's a contract between the Commonwealth and a particular company, then the members and directors of that company, depending on the size, may be influenced by the decisions of the Commonwealth and may be inclined to do and decide certain things in a certain way that would favor the Commonwealth or even their own companies. So the provision has this purpose of lessening any improper relation and influence of the executive on any of the parliamentarians. But the provision does say that there is an exception. If the company is an incorporated company with more than 25 persons, then it's okay for the MP to also be a member of the company. Again, this is because then there would be less possibility and probability of that particular member being influenced and capable of influencing the decisions of the company to favor the Commonwealth or the executive. All in all, these disqualifications of section 44, they exist to preserve the independence and the autonomy of Parliament and of its parliamentarians. If you like the content of this video and if it helped you understand a little bit more about the Constitution, then click the like button and subscribe to our channel. I hope you enjoyed learning more about section 44, and I do hope to see you again next time. Until then, ciao.